Welcome to the 5-Minute Legal Master Series, where expert attorneys help you master important legal topics. Today, board-certified creditors' rights attorney Nicholas D. Krawec discusses contested litigation.
Most matters that are referred to counsel for a collection lawsuit involve situations where no answer is filed by the debtor and a default judgment is entered, and then you just have to worry about locating assets to satisfy that judgment. And while I don't have particular statistics in front of me, I would venture a guess that perhaps 10 to 20% of collection lawsuits result in an answer being filed by the defendant. And quite often those responses are not necessarily answers on the merits. Usually they start out perhaps with a motion to dismiss, or perhaps what we call in Pennsylvania preliminary objections. That is often used to buy some time by the debtor, stall tactic if you will. Or they may file an answer, and if the rules of the jurisdiction allow it, they can file a general denial of the claims in the complaint or a demand for proof. And as I said, similarly that might be to buy some additional time. But you're going to get an answer on the merits. Sometimes you're going to get affirmative defenses to which you'll have to respond. And sometimes you may get a counterclaim, a countersuit from the defendant for damages. May involve factual allegations that you, perhaps as the credit manager, may not be aware of. The debtor may assert as a defense certain alleged promises or representations made by the sales representative who handled the transaction. He may make an allegation of non-conforming delivery or defective products or services or late delivery, may allege a pricing dispute, and can file a counterclaim seeking consequential damages as a result of any of these alleged factors that he's claiming occurred in the transaction. He may claim to have had to effect cover by buying replacement goods for the non-conforming goods that the plaintiff sold to him at a higher cost, and he's trying to recover that supposed higher cost from the creditor who sold the goods to him. The counterclaim causes unforeseen expenses to you as the creditor. You're faced with paying an attorney to defend against the counterclaim on an hourly basis. However, you want to keep in mind, too, that a counterclaim may often be used as leverage by a defendant to try to negotiate what's often called a walkaway, or what many of us know as a mutual dismissal. So, in any event, you've got some contested litigation on your hands, and you're in it for the duration. And the question is, what can you expect? Well, first off, you can expect some delay. Don't count on that money coming in for a long time, because you're going to have to litigate this matter to judgment or negotiate a settlement. The delay is going to be resulting from these preliminary arguments and briefings and preliminary court appearances, resulting from perhaps these motions to dismiss or preliminary objections. But your time is going to be taken up helping counsel to respond to the affirmative defenses and to the counterclaim. There's going to be pretrial discovery you're going to have some involvement in. That's going to be the subject of another legal master presentation. Your time is going to be taken up responding to written discovery, interrogatories, document requests. You may be required to attend a deposition where you have to give testimony at the deposition. It's going to disrupt your business routine and perhaps that of others in your company that have knowledge of the transaction, knowledge of the facts, and are important witnesses in the case. There may be possibly multiple evidentiary hearings involved depending on the amount of the claim and where a suit is filed and whether a witness will be needed. Many jurisdictions have small claims courts where you file a claim amounts under a certain dollar threshold, and there's an appeal as a matter of right to the next level of the court. In Pennsylvania, that's called a magisterial district court, where you can file an appeal from the decision of that court to the Common Pleas Arbitration Division. You'll need a witness there if it continues to be contested. Some jurisdictions don't have arbitration, but in any event, you're going to need a witness in a contested matter, and it's going to involve you as the creditor collection manager. What kind of witness will you need? Well, you really shouldn't take shortcuts with witnesses. The witness is going to present your case on damages. There may be other witnesses that have knowledge of the transactions, but you can't take a shortcut with witnesses. You can't coach someone, you can't prep someone, because then there's going to be problems with hearsay evidence. There's going to be problems with that witness who doesn't have first-hand knowledge standing up under cross-examination. In most collection lawsuits, your business records and documentation are paramount. The trustworthiness and accuracy of those records is very important. Those collection matters are often document intensive. What you need to do to be prepared for contested litigation starts from day one. Day one is presume that someday your new customer and all the euphoria of this new account that you've got may turn into a debtor, and you may be called upon to prove your case in court. Keep that in mind as you maintain your business records and as you deal with your people involved in the transaction, whether they're sales representatives, collection representatives, or credit management personnel. Thank you.
You've just heard the 5-Minute Legal Master, where expert attorneys help you master important legal topics. For more information on this and other topics, please visit 5minutelegalmaster.com.